If you're watching this unfold right now on February 16, 2026, at this late hour when most of Manhattan sleeps, you need to understand what just happened, because the tremors are already shaking the foundations of American political and legal norms in ways that will define this decade. Just moments ago, the Manhattan District Attorney's Office issued an arrest warrant connected to ongoing criminal proceedings involving Donald Trump. And within minutes, the response on Fifth Avenue became impossible to ignore. New York City Police Department units moved with precision and speed, establishing hardened perimeters around Trump Tower, sealing entrances with barricades, restricting elevator access, and deploying tactical coordination that signals this is no symbolic gesture, but procedural enforcement at maximum velocity. Officers in tactical gear took positions at every access point, while federal and local authorities synchronized communications in real time, transforming the iconic Golden Tower from a residence and business hub into a secured crime scene under judicial authority. This wasn't crowd management or political theater. This was the machinery of criminal justice engaging at full operational capacity against a former president of the United States. And once that machinery activates with this level of intensity, reversal becomes nearly impossible. Arrest warrants of this magnitude don't materialize from impulse or political whim, but from methodical grand jury proceedings, where prosecutors present evidence under oath, where witnesses testify to financial transactions and communications, and where judges review probable cause before signing orders that compel immediate action. When the Manhattan District Attorney authorizes enforcement involving Donald Trump, it signals that investigators believe they've crossed the legal threshold with documentary evidence strong enough to survive defense challenges and appellate scrutiny. Timing in criminal prosecution is rarely accidental. Prosecutors wait until investigative threads converge, until witness cooperation is locked under immunity deals, until financial trails are mapped through subpoenaed records, and until legal theories are fortified against motions to dismiss. The speed with which law enforcement established control around Trump Tower suggests operational readiness was built weeks in advance, with security protocols rehearsed, judicial authorization secured, and contingency plans activated the moment the warrant cleared the judge's desk. High-profile enforcement actions require choreography that balances public safety with constitutional procedure, and the visible deployment of uniformed officers alongside plainclothes investigators indicates this operation was designed for both deterrence and documentation. The types of matters falling under Manhattan jurisdiction typically involve business record integrity, financial misrepresentation, and transactional compliance. Cases built not on dramatic confrontations, but on paper trails that prosecutors can trace through bank statements, invoices, and communications that reveal intent. These structurally resilient cases survive courtroom battles because documentation doesn't change testimony. Numbers don't fade with memory, and signed agreements speak louder than denials. When prosecutors believe records demonstrate fraudulent intent or deliberate concealment, they move with precision that reflects confidence in evidentiary foundations. Another critical factor driving this timing is procedural posture. Once a grand jury returns an indictment or a judge signs a warrant, the system transitions from investigation mode to enforcement mode. And at that stage, delay becomes legally difficult. Defense strategies shift from avoidance to response, from challenging subpoenas to negotiating arraignment logistics. And the machinery of booking procedures, fingerprinting protocols, and courtroom scheduling begins moving with predictable momentum that political pressure cannot easily derail. Inside Trump Tower, activity reportedly froze as law enforcement took control, elevators restricted to authorized personnel, movement monitored through internal security systems, and occupants directed to remain in place while officers preserved potential evidence and ensured compliance. Law enforcement doesn't deploy this level of control for publicity. They do it to prevent destruction of documents, to stop unauthorized departures, and to maintain officer safety in environments where emotions run high and unpredictability is assumed. The choreography reflects lessons learned from decades of high-stakes arrest, where one misstep can compromise entire cases, where one leaked exit can turn enforcement into spectacle, and where procedural errors can hand defense attorneys grounds for dismissal. This is the machinery of the criminal justice system operating in full public view against someone who once commanded executive authority over that same system. And the institutional tension is palpable because courts must project neutrality while operating under a spotlight that scrutinizes every gesture for evidence of bias or favoritism. Once an arrest warrant is issued by the Manhattan District Attorney, especially one involving a former president, the process becomes rigid and largely immune to political interference because judicial oversight replaces prosecutorial discretion. If and when Donald Trump is taken into custody under this warrant, the steps that follow are standardized under New York criminal procedure: identification through booking systems, fingerprinting for official records, formal notification of charges read into the legal record, and processing that treats the defendant as subject to the same rules that govern every arrestee, regardless of fame or fortune. In high-profile cases, these steps are often coordinated to minimize disruption while preserving integrity, sometimes occurring in controlled environments away from crowds, sometimes scheduled to avoid media frenzies, but always documented with precision that anticipates future appeals. The point at this stage is not punishment, but jurisdiction, establishing that the court has lawful authority over the defendant and that compliance with future orders is legally enforceable. The next critical moment is arraignment, where charges are read into the public record before a judge, where prosecutors outline the legal basis for the arrest with enough specificity to satisfy due process, and where the judge addresses bail or release conditions based on statutory factors rather than public sentiment. Contrary to popular belief, arraignment is not about guilt or innocence, but about whether the court has jurisdiction and whether conditions are necessary to ensure the defendant's future appearance. Trump's legal team would be operating on parallel tracks at this point. One team focused on immediate logistics like court access and scheduling, another preparing pretrial motions aimed at limiting evidence, challenging jurisdiction, or narrowing charges through legal arguments that delay substantive proceedings. But here's the crucial point. Once arraignment occurs, the case enters a public timeline where filings are docketed, hearings are scheduled, deadlines are imposed by judicial order, and delay becomes harder to manufacture because courts manage the pace through procedural rules that apply equally regardless of the defendant's resources or political connections. What makes this moment so consequential is visibility. This is not a sealed process unfolding quietly behind courtroom doors, but a public spectacle under judicial supervision with press scrutiny and procedural transparency that creates a permanent legal record. Every motion filed becomes part of that record. Every ruling issued establishes precedent. And every courtroom exchange is transcribed for appellate review. Because once the defendant stands before a Manhattan judge and enters a plea, the narrative shifts decisively from political commentary to court-managed process governed by rules of evidence, timelines enforced by judicial authority, and standards that don't bend easily to power or reputation. This is where public intuition often collides with legal reality, because many people immediately ask whether the defendant will be held, released, or restricted. But bail is not a referendum on fame or politics, but a risk assessment grounded in statute and judicial discretion. In New York, judges focus on narrow statutory factors, the defendant's likelihood of returning to court based on past compliance, access to resources that could facilitate flight, and whether conditions are necessary to protect the integrity of proceedings from witness tampering or evidence destruction. Bail is not meant to punish, but to secure appearance and compliance, which means a judge evaluating Donald Trump would weigh concrete procedural risks rather than cable news narratives or crowd reactions. Those risks include international connections, access to private aviation, and the ability to influence witnesses through public statements or financial pressure. In high-profile cases, judges often favor non-monetary conditions that are enforceable and reviewable: surrender of travel documents to prevent international flight, restrictions on interstate travel without court approval, limitations on contact with witnesses identified in charging documents, and mandatory check-ins with pretrial services that create accountability without detention. These tools allow the court to maintain control without resorting to incarceration. And judicial caution cuts both ways, because status does not automatically mean leniency. Visibility can increase scrutiny because a judge may reason that any violation of conditions would have outsized consequences for public confidence in the system, making clear, enforceable rules more likely rather than less. This is why observers should be careful about assumptions. The bail phase is not dramatic in appearance, but decisive in effect, because it establishes the court's authority and sets boundaries for everything that follows. Once conditions are imposed, compliance becomes a continuing legal obligation, with real consequences for even minor violations. And defense attorneys know that challenging bail conditions can backfire by signaling to the court that the defendant poses greater risks than initially assessed. As cameras remain fixed on Manhattan and as legal experts urge caution, the immediate question echoing across legal and political circles is whether this marks the start of a prolonged battle or a turning point that reshapes political norms in ways few anticipated. What began as a warrant may ultimately become a defining chapter in American political history, testing whether institutions can convince a polarized public that they act independently, untethered from politics, polling, or protest. The slow grind of procedure clashes with the public's appetite for instant outcomes, creating frustration and misinformation along the way. But whether this episode ends quietly or escalates dramatically, it marks a threshold moment where the intersection of criminal law, presidential politics, and real-time media has never been this intense. For now, the city waits, the courts prepare, and the nation watches as a legal process unfolds that could reshape how future prosecutors approach powerful figures and how the public interprets those decisions for a generation.